Good morning, everyone. I am Apple May L. Casas, your first reporter for today. And before I start, I would like to apologize if I'm only using recorded video for my report. It's because I have important matters to do, and I hope you understand. So, let's start. So now we're already at Article 1244, in which it states that the debtor of a thing cannot compel the creditor to receive a different one, although the latter may be of the same value as or more valuable than which is due. So, in obligation to do or not to do, an act or forbearance cannot be substituted by another act or forbearance against the obligee's will. So, the prestation mismo ang dapat ihatag as payment para ma-extinguish ang obligation. So, the first paragraph refers to a real obligation to deliver a specific thing. So, a thing different from that due cannot be offered or demanded against the will of the creditor or the debtor, as the case may be. And the second paragraph, it refers to the personal obligations. The act to be performed or the act prohibited cannot be substituted against the obligee's will. So, example, A owes BMX bike to B, and since the stipulated time is due, A cannot find the same brand of BMX bike to replace the B's choice as A owed to latter. Since A has the mountain bike, much costly than BMX bike of B, the latter cannot be forced to accept by A's offer of mountain bike. So A cannot force B to accept the mountain bike because what is stipulated is a BMX bike, and the real obligation of A is to deliver the specific thing. Next is we have the Article 1245, in which it states that the dation in payment whereby property is alienated to the creditor in satisfaction of a debt in money shall be governed by the law of sales. So there are four special forms of payments under the Civil Code, namely dation in payment, and that is to be discussed in this article, Article 1245. Second is the application of payments, to be discussed in Article 1253. Third is the payment by cession, to be discussed in Article 1255. And fourth is the tender of payment and consignment, to be discussed in Article 1256 to Article 1261. And strictly speaking, application of payment is not a special form of payment. So going back, Article 1245 is all about the dation in payment. So what is dation in payment, DI? So dation in payment is also called as adjudication or dasyon in pago. It is the conveyance of ownership of a thing as an accepted equivalent of performance. So it is a special form of payment because it is not the ordinary way of extinguishing an obligation. An existing debt in money is satisfied not by payment of money but by alienation of property. So, it is a special form of payment whereby the ownership of property is transferred to his creditor to pay a debt in money. And there is a dation in payment when property is alienated to the creditor in satisfaction of a debt in money. Here, the debtor delivers and transmits the creditor the former ownership over a thing as an accepted equivalent of the payment or performance of an outstanding debt. Example, D owes C 50,000. On due date, D proposes to C to accept a ring in payment of D's debt of 50,000. C agrees to this proposal and accept the ring. So, this monetary obligation is extinguished by dation in payment. Governing law. The law of sale governs because dation in payment may be considered a specie of sale in which the amount of the money that become the price of the thing alienated. Article 1245 provides the law on sales shall apply, since undertaking really partakes in one sense of the nature of sale. That is, the creditor is really buying the thing or property of the debtor. The payment for which is to be charged against in the debtor's obligation. Dation in payment extinguish the obligation to the extent of the value of the thing delivered. either as agreed upon by parties or as may be proved, unless the parties by agreement is expressed or implied, or their silence consider the thing as equivalent to the obligation, in which case the obligation is totally extinguished. Next is we have the Article 1246, in which it stated that when the obligation consists in the delivery of an indeterminate or generic thing whose quality and circumstances have not been stated, then the creditor cannot demand a thing of superior quality, and the purpose of the obligation and other circumstances shall be taken into consideration. So, the debtor who is obliged to deliver a generic thing cannot be compelled to deliver a thing of superior quality. Neither can he compel the creditor to accept a thing of inferior quality. Delivery of an average or medium quality will be sufficient taking into account, and that is the purpose of the obligation. So, rules of medium quality. So, according to what I have reported earlier, in Article 1244, if the obligation consists in the delivery of a specific thing, then the very thing due must be delivered. So, the specific thing mismo ang i-deliver. However, if the purpose of the obligation is to deliver a generic thing, which is not a specific thing, then the purpose of the obligation and other circumstances shall be taken into consideration to determine the quality or kind of thing to be delivered. So, example, Mario promised to deliver Luigi a horse. Luigi cannot compel Mario to deliver a prize-winning racehorse. Neither Mario required Luigi to accept an old sickly horse. So again, in this article, it was mentioned that circumstances shall be taken into consideration to determine the quality or kind of thing to be delivered. Now, let's consider this situation. First, if Luigi owns a stable of racehorses and horse racing is his main diversion of life, which is fact known to Mario, and the price agreed upon is the reasonable price of a racehorse, then Mario must deliver a racehorse. Second is if Luigi happens to be a Kalasa driver and Luigi agreed to pay Mario for the horse an amount which is reasonable price of a horse for Kalasa, then that kind of horse may be delivered. But if Luigi is a veterinary doctor and his only purpose in buying a horse is to examine its organs, and in connection with his work, this and other relevant circumstances may show that the old sickly horse was intended by the parties to be delivered. Article 1247. Unless it is otherwise stipulated, the extrajudicial expenses required by the payment shall be for the account of the debtor. With regard to judicial costs, the rules of court shall govern. So the extrajudicial expenses of payment are for the account of the debtor. For the reason is that the obligation is extinguished when payment is made, and it is therefore the debtor who is primarily benefited. Extrajudicial expenses are the fees or expenses that a lawyer may charge for professional services or in addition to legal costs, and which result from the exercise of the profession of lawyer. So, if the parties have made a stipulation as to who will bear the expenses, then their stipulation shall be followed. So, if they have made an conditions or agreement on who will bear the expenses, then their agreement will follow. Note, Article 1247 does not apply to expenses incurred by the creditor in going to the debtor's domicile to collect. On the other hand, losing party generally pays judicial costs. So, judicial costs are the statutory amount allowed to a party to an action for his expenses incurred in the action. Judicial costs are the costs other than payment to lawyers that are connected with taking a case to a court of law. And under the Rules of Court, Section 1, Rule 142, the cost of an action as a rule be paid by losing the party. The court may, however, for a special reason, adjudge that either party shall pay the cost or that the same be divided as may be equitable. So no costs are allowed against the government unless otherwise provided by law. Example, Mark is the owner of an apartment entered into a lease agreement with Joseph for the amount of 3,000 to be paid every 5th of the month. However, Joseph failed to make the payment for 4 months despite oral demands. Mark wishes to have Joseph vacate the property and collect the unpaid rental fee. He then seeks the service of attorney de la Torre and paid fee of 5,000. So 2 demand letters were sent via registered mail and incurred 350 pesos for such. Later on, Joseph forwarded his intent to vacate the apartment and make the payment for his debt, which shall include the unpaid rental and the expenses incurred upon hiring legal service. So the expenses incurred upon hiring legal service is included on the debtor's payments since it is extrajudicial expenses. So the general rule in this article is that the debtor has to pay for the extrajudicial expenses incurred during the payment. So it is the debtor who benefits primarily since his obligation is thus extinguished. And the only exception is that when there is a stipulation to that contrary. So now let's proceed to Article 1248, in which it states that unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prostration in which the obligation consists. Neither may the debtor be required to make partial payments. However, when the debt is in part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidation of the latter. So, the performance of obligation should be complete. Under Article 1233 of the Civil Code, a debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. Hence, partial performance is not allowed generally under Article 1248. So, in order the payment may extinguish an obligation, it is necessary that there should be complete performance of the prostration, and the creditor may accept but he cannot be compelled to accept partial performance. The debtor has the duty to comply with the whole of the obligation, but he cannot be required to make partial payment if he does not wish to do so. So when is partial performance is allowed? First is when there is an express stipulation to that effect. Second is when the debt is in part liquidated and in part unliquidated. So in which case, performance of the liquidated part may be insisted upon either by the debtor or the creditor. Example, Mark owes Christian 3 million pesos plus damages. So even if the amount of damages has not yet been ascertained, the 3 million is already known or liquidated. This is already dependable and payable. Third is when the different prostration in which the obligation consists are subject to different terms or condition, which affect some of them. So example of this is a debt payable in installments. So example, Dior is in debt to Carl for 5,000 due today. Dior cannot compel Carl to receive 4,000 in partial payment of the obligation, and neither can Carl require Dior to pay only 4,000 unless there is an agreement to the contrary. Second is if Dior owes Carl 5,000 plus the share of Carl from profit of a business which, however, has not yet been liquidated or determined, Carl may demand and Dior may effect the payment of 5,000 which is already known. Third is if 4,000 of the debt of Dior is due today and 1,000 is tomorrow, the obligation can be complied with partially. Similarly, partial performance may be affected in case the payment of the 1,000 is subject to the fulfillment of the condition. Article 1249. The payment of the debt in money shall be made in the currency stipulated, and if it is not possible to deliver such currency, then the currency which is legal tender in the Philippines. The delivery of the notes payable to order or bills of exchange or other mercantile documents shall produce the effect of payment only when they have been cashed or when through the fault of the creditor that have been impaired. So in the meantime, the action derived from the original obligation shall be held in abeyance. So what is legal tender? Legal tender is that currency which, if offered by the debtor in the right amount, the creditor must accept in payment of a debt in money. So legal tender refers to the currency which may be used for payments of debts, whether public or private, and which the creditor cannot refuse to accept. Legal tender in the Philippines. Debts in money shall be paid in the currency stipulated. In the Philippines, all coins and notes issued by Bangko Sentral ng Pilipinas or BSP constitute legal tender for all debts, both public or private. And unless otherwise fixed by the Monetary Board of the BSP, coins are legal tender for amounts for denomination of 10 centavo or less are legal tender up to 20 pesos only. For denominations of 25 centavo above are legal tender up to 50 pesos. All coins and bills above 1 peso are therefore valid legal renders for any amount. So there is a limit in the use of coins as legal tender to release the creditor from the burden of counting huge amount of money in coins, and the creditor will find it troublesome not only to count but also to carry them. So he may not accept coins as payment beyond what the law allows. So payment by means of instrument of credits. Number 1. The right of creditor to refuse or accept. Promissory notes, checks, bills of exchange, and other documents are not legal tender. Therefore, the creditor cannot be compelled to accept them. But the creditor, however, if he chooses them without the acceptance producing the effect of payment, in the meantime, the demandability of the original obligation is suspended. Next is the creditor must cash the instrument, and it is only when it is dishonored that he can bring an action for non-payment for the debt. 2 is effect on obligation. So, until they have been cashed and unless they have been impaired through the fault of the creditor. So, to further understand, here is the example. Example, DJ owes Kali 10,000 which is due today. Here, payment in cash and in legal tender is implied. Kali can legally refuse to accept a check from DJ and insist on payment in cash. He has the legal right to treat their contract as breach unless DJ implies. If Kali accepts, there is no payment yet until the check has been cashed or went through his fault. It has been impaired as when he has delayed in presenting the check for payment for an unreasonable length of time, and the check has lost its value by reason of the insolvency of the bank. And the payment by check is considered to be only a conditional payment. DJ is not finally released until the check has been honored by bank on which it was drawn. But until the check is dishonored, Kali cannot demand the payment of the obligation. Next, Article 1250. In case of an extraordinary inflation or deflation of the currency stipulated should supervene, so the value of the currency at the time of the establishment of the obligation shall be the basis of payment, unless there is an agreement to the contrary. First, let's look at the meaning of inflation and deflation. So, according to Webster's dictionary, inflation is a sharp, sudden increase of money or credit or both without corresponding increase in business transaction. Inflation causes drop in the value of money, resulting in the rise of general price label. On the other hand, deflation is the reduction in volume and circulation of the available money or credit, resulting in the decline of general price level. It is the opposite of inflation. Basis of payment in case of extraordinary inflation or deflation. Under Article 1250, the purchasing value of the currency at the time of establishment of the basis of payment. This is, however, subject to agreement of the parties to the contrary. So the inflation or deflation in this case must be extraordinary, meaning it is not a universal trend which did not spare the country. Extraordinary inflation exists when there is a decrease or increase in the purchasing power of the Philippine currency, which is unusual beyond the common fluctuation on the value of said currency, and such increase or decrease could not have been reasonably foreseen or was manifestly beyond the contemplation of the parties at the time of the establishment of the obligation. So example, Ding borrowed Kong 5,000 payable after 5 years. On the maturity of the obligation, the value of 5,000 dropped to 2,500 because of inflation, or increased to 10,000 because of deflation. So in this case, assuming that there is an extraordinary inflation or deflation, so the basis of the payment shall be the equivalent value of the currency today to that 5 years ago. Hence, Ding is liable to pay Kong 10,000 or 2,500 unless there is an agreement to the contrary, such as that Ding pay Kong 5,000 regardless of an extraordinary decrease or increase in the purchasing power of the peso. So, there is a chance here in the Philippines that there will be inflation and deflation. So, pwede mo taas o muubos ang value sa money. But again, if there is an agreement to the contrary, so Ding shall pay 5,000 regardless of any extraordinary decrease or increase in the purchasing power of the peso. Note that the provision of Article 1250 requires for its application a declaration of inflation and deflation by the central bank. And without such declaration, creditors cannot demand an increase and debtors a decrease of what is due to or from them. Next, Article 1251. So payment shall be made in the place designated in the obligation, and there is no express stipulation, and if the undertaking is to deliver a determinate thing, the payment shall be made wherever the thing might be at the moment the obligation was constituted. And in any other case, the place of payment shall be domicile of the debtor. And if the debtor changes his domicile in bad faith after he has incurred in delay, the additional expenses shall be borne by him. This provision are without prejudice to venue under the rules of court. So, place where obligation shall be paid. Article 1251 gives the rules regarding the place for the payment of an obligation without prejudice to venue under the rules of court. First, if there is a stipulation, so the payment shall be made in the designated place. Second is if there is a stipulation and the thing to be delivered is specific. So the payment shall be made at the place where the thing was at the perfection of the contract. Third is that there is no stipulation and the thing to be delivered is generic. So the place of the payment will be the domicile of the debtor. In this case, the creditor bears expenses in going to the debtor's place to accept the payment. Note that venue is the place where a court suit or action must be filed or instituted. So this venue is the location where a case is heard. On the other hand, domicile is the place of a person's habitual residence, and that is according to Article 50. And residence is only an element of domicile. So a residence is a home you expect to live in for a temporary period, whereas a domicile is a home you plan to live for an indefinite period. Any place you own property or live for a prescribed period can be your residence, but only the one site where you intend to make your permanent home and remain indefinitely can be your domicile. Thus, you can have many residents, but you can only have one domicile in one intended place. So, it is believed that the term domicile, as used in Article 1251, connotes actual as distinguished from legal residence. So, example, S obliged himself to deliver B a specific refrigerator. So it was agreed that the refrigerator shall be delivered at B's house. So the house of B shall be the place of delivery. Second is if there is no agreement as to the place of delivery and the refrigerator was in the house of C, when the parties entered into contract, the delivery shall be made at the house of C. But if the refrigerator was temporarily at some place, like it is on a ship in transit, the place of delivery shall be the domicile of S unless otherwise stipulated. Third is the obligation of S is to pay B a sum of money, a generic thing. The place of payment is that designated in the obligation. Otherwise, B must have to go to the house of S to receive payment. B incurred the expenses incidental to such collection. If S changed his domicile in bad faith or after he has incurred in delay, the additional expenses shall be borne by him. So that would be all for my report. Thank you for listening.